I had barely stepped out of my truck when the first wave of HOA smugness hit me. A tall, sharply dressed man with a clipboard and a kind of condescending smirk that told me he thought he was in charge here. His name, as he would later inform me with an unnecessary amount of self-importance, was Brad, the HOA president, and he came striding across the driveway like he was inspecting a piece of property that might fail his standards, even though this wasn't even technically inside his HOA. "Afternoon," he called, looking me up and down before his eyes shifted toward the moving van behind me. "You must be new. Welcome to Maple Ridge. But before you start unloading, we'll need to go over a few important community requirements." I raised an eyebrow, already sensing that requirements meant rules I just made up to push you around, but I decided to play along for a moment, curious to see what game he thought he was playing. He launched into a polished spiel about annual dues, initiation fees, and a temporary compliance deposit, the last one being a completely fabricated term I'd never heard in my life. And then, with a rehearsed flourish, he handed me a manila envelope containing a welcome packet and an invoice for $2,750 due immediately to avoid violations. It was almost impressive how quickly they moved to squeeze a new arrival. I hadn't even unlocked my front door yet, but what made it even more laughable was that my property, a cabin on 3 acres, sat entirely outside of their HOA boundary. I knew this because not only had I studied the plat maps before buying it, but I was also the landlord of the commercial strip where the HOA's own office lease was located, meaning Brad and his little board paid rent to me every month without realizing who I was. I glanced at the invoice and then back at him, pretending to look puzzled instead of amused, and asked, "And if I don't pay?" Brad's smirk widened into something he clearly thought was intimidating as he said, "Then we'll have no choice but to begin the violation process. Citations, fines, and potential liens. It's all in the bylaws." I nodded slowly, resisting the urge to laugh, and replied, "Interesting. Because I'm pretty sure your bylaws don't apply to me." His smirk faltered just a bit, but he recovered quickly, insisting, "Everyone who lives here is subject to HOA rules." I let him dig himself deeper for another few minutes before casually dropping the first hint, saying, "You might want to check your lease agreement before you get too carried away." He blinked, clearly thrown, and asked what lease I was talking about, so I told him I'd be happy to explain, but only after I finished moving in. Over the next few hours, Brad made a couple of thinly veiled attempts to inspect my property, walking the edge of my lot like he was looking for something to nitpick, but each time I caught him, I simply waved and went back to unpacking, letting him stew in confusion. The truth was, I had been warned about Maple Ridge's HOA. Before I bought this cabin, the previous owner told me stories about board members wandering onto non-HOA property and trying to bully owners into paying community contributions that weren't legally enforceable, and I'd been prepared for their nonsense from day one. What they didn't know yet was that I had already pulled the lease agreements for every commercial unit in the strip mall I owned just down the road, and that the Maple Ridge HOA office was one of my tenants, locked into a 5-year lease, with a clause that gave me enormous power if they defaulted or violated terms. By the time the sun started dipping low, Brad returned with backup, a woman named Cheryl, the HOA treasurer, carrying a folder stuffed with papers she clearly thought would scare me into compliance. She started rattling off violations, like having an unapproved mailbox style and failing to submit landscaping plans, and I let her finish before I calmly said, "You're going to feel pretty silly when you realize I'm not under your jurisdiction." Cheryl's smile tightened, but she doubled down, saying, "Everyone in this area is part of the Maple Ridge community. We maintain the roads, the lighting, the signage." I just looked at her and asked, "And how do you pay for all that?" She blinked, said, "Dues," and I followed with, "Right, dues that you pay out of an account that gets funded partly by rent from your office space." My office space. The silence that followed was delicious. Brad stared at me like I had just spoken in another language, and I decided to put them out of their misery, explaining that I was their landlord. I had the signed lease in my truck, and I knew exactly how much they paid me every month. So maybe think twice before threatening me with fines, I said. Because if you make me your enemy, I have legal ways of making your lives very uncomfortable. Brad's face went red, Cheryl's went pale, and neither of them had a comeback. They muttered something about needing to check records before leaving. But I knew this was far from over. I was like, this didn't just roll over and admit defeat, especially when their egos were bruised. What they didn't realize was that I was ready for whatever tricks they had next, and if they wanted to play games, I could play better. After all, I wasn't just another cabin owner. I was the one holding the keys to their office, their rent payments, and a clause in their lease that could change everything for them with one notice. The next morning started quietly enough, though I half expected a knock at my door before I even finished my first cup of coffee, and sure enough, right at 8:15, I spotted Brad's familiar stride coming up my driveway again, this time accompanied by a different face, a man in a navy polo shirt embroidered with Maple Ridge HOA compliance officer in gold thread, carrying a camera and clipboard like he was about to perform an inspection for the city. I stayed seated on my porch, sipping my coffee while they approached, and before they could say a word, I cheerfully greeted them with, "Morning, tenants," just to watch the confusion ripple across their faces again. The compliance guy, whose name tag read Doug, frowned and said, "We're here to conduct a preliminary property compliance survey. It's routine for all new residents," in the kind of monotone that screamed rehearsed policy talk, and I replied, "That's nice, but this property isn't in Maple Ridge's jurisdiction, so your survey isn't welcome or valid." Brad quickly interjected, "Sir, refusing a compliance survey is itself a violation." Clearly trying to regain control of the conversation, but I just raised an eyebrow and said, "A violation according to what? Your OO bylaws? You might want to actually read the boundaries section in your own charter. You'll notice this address isn't included." Doug, perhaps trying to look professional, started taking photos of my porch, my driveway, even the tools I had leaning against my garage, and that's when I stood up, walked over, and said in a calm but firm voice, "You have approximately 5 seconds to get off my property before I call the sheriff for trespassing." Doug hesitated, glancing at Brad for instruction, but Brad didn't back down, instead saying, "We're empowered to enforce community standards for all properties connected to Maple Ridge infrastructure." I couldn't help but laugh at that. Because I'd already done my homework. The road to my cabin was maintained by the county. My utilities were independent, and the only connection I had to their infrastructure was the fact that my land happened to be near theirs. I pulled my phone from my pocket, scrolled for a moment, and then held up the county parcel map with the HOAS official boundary lines highlighted in bright yellow, my property. A large green rectangle sat completely outside it. "You see this?" I said, tapping the screen. "That means you have no legal authority here whatsoever, and if you keep pushing it, I'll have your office lease flagged for breach under the harassment clause." Brad's mouth opened like he wanted to argue, but no words came out, and I could see Doug shifting uncomfortably. Sensing the opportunity to twist the knife, I added, "Oh, and just so you know, rent's due in 5 days. I'd hate for there to be any issues with payment this month." Brad's face flushed, and without another word he turned and walked back toward the road, Doug trailing behind like a scolded intern. I figured that would buy me at least a couple of days of peace, but apparently the HOA wasn't done trying. To assert some imaginary control, later that afternoon, a certified letter arrived, stamped with Maple Ridge's official seal, stating that my membership dues were delinquent and threatening to place a lien on my property if payment wasn't received within 10 days. I almost spit out my drink laughing, because not only could they not legally lien a property outside their boundaries, but sending that letter could actually open them up to legal trouble for fraud and harassment. I decided it was time to start. Keeping a paper trail, I scanned the letter, documented the previous day's interaction, and sent copies to my attorney along with a note explaining that I might need to file a formal cease and desist. My lawyer, a no-nonsense woman named Dana, called me within the hour, chuckling as she read the letter aloud and said, "Oh, this is going to be fun." She advised me to respond in writing, clearly stating their lack of jurisdiction and warning. Then that further attempts to bill me would be considered harassment and a violation of state consumer protection laws? I took her advice, but I didn't just stop there. I also included a polite reminder in my letter that the HOA office lease was subject to immediate termination if they were found engaging in illegal activity from that address. And since my commercial property lease terms gave me wide discretion on such matters, they might want to think long and hard before escalating. The letter went out certified mail that same day, and I knew it would land on Brad's desk by Monday morning. Sure enough, 2 days later, I saw him pacing in front of their office building when I happened to drive by on my way into town, his phone pressed to his ear, his free hand gesturing wildly. Curiosity got the better of me, so I stopped at the coffee shop next door, grabbed a table by the window, and watched as Cheryl emerged from the building carrying a stack of papers, her face pinched tight like someone who'd just seen their credit card statement after a month of bad decisions. They both disappeared back inside, and about 20 minutes later, I got a call, not from Brad, but from an unfamiliar number that turned out to be their HOA's community liaison. A man named Peter who tried to smooth things over by saying there had been a clerical mistake and that the billing letter was automatically generated. I let him ramble for a bit before asking, so the compliance visits, the bogus invoice, and the threats of fines were also clerical mistakes? There was a long pause on the line before Peter awkwardly said, "We'd like to extend an invitation to meet with the board to clear the air." I declined, telling him there was nothing to discuss unless it was about their rent payment or their official written acknowledgement that they had no authority over my property. Peter tried to pivot back into PR mode, but I cut him off and said, "Tell Brad and Cheryl that if they so much as step foot on my property again without an invitation, I'll have them trespassed and I'll start exploring options for terminating their lease early. I'm sure they'd love to find new office space in this market." He sputtered something about misunderstanding, but I ended the call there, feeling the balance of power shift firmly in my favor. The thing about people like Brad is that they can't stand losing face, and the more you push back, the more desperate they get to reassert control, which meant I knew they weren't done, and whatever came next would probably be even floppier than their first attempts. The only question was whether I wanted to just shut them down or have a little fun in the process, and given their arrogance so far, I was starting to lean toward the latter. By the time the next HOA meeting rolled around, the air was thick with anticipation, resentment, and just enough desperation to keep things interesting. Because while I had politely, or at least professionally, handed them copies of the lease agreement proving I was effectively their landlord, it was obvious they hadn't fully processed what that meant for their precious little empire, and now here I was walking into the very community center they proudly claimed as HOA headquarters, only to note the subtle shift in body language, as members whispered to each other, some frowning, others looking like they'd bitten into a lemon, and Karen, yes, that Karen, the self-appointed queen bee with the platinum blonde bob and a glare sharp enough to cut drywall, sat at the head of the table like a dethroned monarch, lips tight, her gavel resting uselessly in front of her. The meeting began with what they called community updates, which was HOA speak for Karen rambling about shrub heights, approved mailbox colors, and the alleged menace of people leaving trash cans visible for more than 12 seconds after pickup, but it didn't take long for her to pivot toward what she clearly wanted to be the main event, me, as she smoothed her papers, adjusted her cardigan, and in that faux conciliatory voice that people use when they're trying to bait you into an argument, said, "Of course we've had some confusion lately about property lines and lease agreements, and I'd like to clear that up for everyone here," prompting a few murmurs of approval from the peanut gallery while I simply sat back, pen in hand scribbling notes as if I were the teacher grading a very poorly thought-out essay. Karen launched into her version of events, claiming that while I technically held the master lease on certain parcels, the HOA bylaws still take precedence in practice because community integrity was paramount, which was both legally laughable and conveniently vague. So when she tried to breeze past that point, I raised my hand not because I needed permission, but because the gesture made her visibly bristle and said, Karen, I think it's adorable you believe bylaws can override a binding lease agreement signed by your board. But the reality is, your HOAS authority stops at the edge of the property you don't own, which, as it turns out, includes your clubhouse, your tennis courts, and a good chunk of the parking you're currently charging residents to use. The room went quiet except for one guy in the back who audibly muttered, "Oh, damn," and Karen's knuckles whitened around her gavel as she sputtered about mutual understanding and historical precedent. So I decided to really drive it home, pulling out a large, laminated property map with my parcels highlighted in bold red, laying it flat on the table, and letting everyone see just how much of their beloved HOA kingdom was actually under my control. Whispers rippled through the crowd as people realized the pool, their beloved 4th of July fireworks launch site, and even the decorative pond with the stone fountain were all on my land, and I leaned forward, my tone calm but edged with steel, explaining that while I wasn't in the business of making life harder for residents, any attempt to enforce HOA fines, fees, or rules on property they didn't own would not only be invalid but could constitute harassment under state law. At which point I casually mentioned that my attorney had already drafted cease and desist letters for such scenarios. One board member, a man named Ted, who had clearly been in Karen's shadow for years, spoke up hesitantly, asking if that meant they couldn't collect the amenity fees they'd been charging for the pool and tennis courts. And I didn't even bother sugarcoating it. "Not unless you plan to cut me a check for rent every month, Ted. And considering the lease rate I charge commercial tenants, I'm not sure you can afford it." That's when the panic set in, with residents starting to turn on each other, demanding to know why they'd been paying for access to amenities that technically belonged to someone else, and Karen trying desperately to regain control by banging her gavel and threatening to remove disruptive attendees, which only made people angrier. Finally, I stood, gathered my papers, and told them plainly that I would be sending a formal notice to the HOA detailing the boundaries of their authority, along with a new usage agreement for my properties, one that would significantly reduce resident costs but require the HOA to pay me if they wanted to keep advertising those amenities as part of their exclusive community perks. And as I walked out with half the room murmuring thanks and the other half glaring daggers, I knew Karen was going to double down rather than back down, because people like her never admit defeat. They just look for another way to claw back control, and I was already preparing for whatever petty, underhanded stunt she thought she could pull next because the game was only getting started. It took less than 72 hours for Karen's next move to materialize, and honestly I had expected her to try something fast. But even I underestimated just how brazen she could be when cornered, because I woke up to find a bright orange notice of violation taped to my cabin door, citing me for, get this, unauthorized alterations to exterior property and failure to maintain landscaping to HOA standards, both of which were laughable on several levels. First, my cabin wasn't even inside their jurisdiction, and second, I had deliberately left the natural wild grass and pine saplings untouched because I liked the privacy and the way the sun cut through the branches in the morning. But here was Karen, acting as if she had the power to order me to mow down the trees on my land. I pulled the notice down, grabbed my coffee, and instead of ignoring it like a sane person might, I decided to use it as ammunition. Because it was one thing for her to run her mouth in a meeting, but leaving a paper trail of overreach was a gift I wasn't about to waste, so I called my attorney, forwarded pictures, and within an hour he had a formal demand letter drafted, citing breach of the lease agreement, harassment, and potential civil penalties for willful misrepresentation of authority. By noon, the letter was delivered to the HOA office via courier, and by 2, I got the first phone call, not from Karen, of course, but from Ted, the board member who looked like he aged 10 years in the last meeting, and his voice was low, almost apologetic, as he said, "Look, I think Karen's going too far here. But she's convinced she can prove some kind of grandfathered jurisdiction," which made me laugh so hard I had to set my coffee down, because if there was some mythical clause giving them rights over my property, it would have surfaced in the dozens of legal reviews before the lease was signed. I told Ted I appreciated his concern, but that this wasn't negotiable, Either they backed off or they'd be facing a lawsuit that could cost them their budget for the next decade. And apparently that conversation got back to Karen because the very next morning she escalated, this time targeting residents, telling them I was planning to fence off the pool, tennis courts, and even the parking lot, which caused predictable outrage. Suddenly, I had 3 different homeowners knocking on my cabin door, asking if it was true, and rather than let Karen's rumor mill keep churning, I invited them in, laid out the property maps, and explained that my only goal was to stop the HOA from illegally charging them for access to land they didn't own, and judging by their faces, it clicked that they'd been paying extra fees for years for something that was already built into their mortgage. Word spread fast, but Karen wasn't about to let the truth get in her way. So her next tactic was pure theater. She scheduled an emergency inspection of the clubhouse and invited the county zoning officer, hoping to catch me in some kind of violation, only to discover that I'd already contacted the county myself and had the zoning officer confirm in writing that not only was I in compliance with every applicable code, but that the HOA had zero authority to enforce anything on my parcels. That document might as well have been a dagger to Karen's plans, but she tried to spin it, telling residents the county was still reviewing the matter. So I decided to go one step further. I printed the county letter in full color, laminated it, and posted copies on the community bulletin board, the clubhouse entrance, and even taped one to the HOS office door, making it impossible for her to keep lying without looking ridiculous. The cracks in her control started to widen. Residents began demanding an emergency election to replace the board. Ted privately told me he was considering resigning, and Karen's once perfectly maintained composure started to slip in public. Her voice rising, her smile tight and forced, her hand clutching that gavel like it was the last weapon she had. Still, I knew she wasn't finished. Because people like her don't retreat quietly, they double down until someone physically removes them from power, and I had the sinking but thrilling feeling that her next play was going to be the kind of desperate, reckless move that would finally give me all the leverage I needed to end her reign for good. And I was ready to not just counter it, but to turn it into the final nail in her HOA coffin. I didn't have to wait long for Karen's big mistake, because exactly 5 days after my laminated county zoning letter went up around the community like a wanted poster for her lies, she committed the one act that guaranteed the HOA's collapse. She trespassed, but not in some minor, "oops, I wandered onto your property" kind of way. No, this was full-blown, deliberate, and documented trespassing, the kind that lawyers salivate over, because she marched onto my parcel with 2 hired maintenance workers, who looked more like guys she picked up from a day labor corner, and paid in cash, and ordered them to start dismantling the old, split-rail fence that had been standing since before the subdivision was built, claiming it was a community hazard and needed to be replaced to meet HOA standards. Never. Mind the fact that the fence sat entirely on my land and was clearly marked on the survey, maps I'd already shoved in her face at least twice. I spotted them from my cabin window, and instead of running out in a rage, I did what any strategic landlord with an HOA on the brink of implosion would do. I grabbed my phone, switched it to video, and started recording from the moment her boots crunched onto my gravel drive. I walked right up, camera steady, and asked her point blank, "Karen, can you point to the section of your bylaws that gives you authority over my fence?" She didn't flinch, just puffed herself up and barked, "I don't need your permission. This fence violates safety code," which was the exact wrong thing to say on record, because now she'd admitted, in her own words, that she thought HO safety code trumped property deeds, county law, and the terms of the lease her board had signed with me. I let her dig her own grave for a few more minutes, even got her to order her workers to keep pulling nails while I reminded her, again for the camera, that she was trespassing and destroying private property. Then I called the sheriff. Not the local deputy she was used to bossing around at ribbon cuttings, but the county sheriff himself, who I knew personally thanks to years of renting land to the county for their seasonal ranger station. 20 minutes later, 2 patrol trucks rolled in, and suddenly Karen's confident HOA president act melted into a red-faced mess of stammers about community interest and authorized enforcement, none of which impressed the Deputies, especially after I showed them the deed, the lease agreement, and the county zoning letter, the combination of which made it crystal clear that she had no legal standing. The deputies took statements, photographed the damage, and even pulled her workers aside, who quickly admitted she'd told them they were fixing a public fence and hadn't mentioned it was private property. That was enough for the deputies to escort her off my land, but not before handing her a citation for trespassing and property damage. And as they drove away, the look on her face was a mix of shock and barely contained fury, like she couldn't comprehend how her little empire's rules suddenly didn't matter. I thought maybe that would be her breaking point, but I underestimated just how far she'd go to cling to power within 24 hours. She sent out an urgent HOA notice accusing me of interfering with community safety improvements and warning residents that their insurance premiums could rise due to his obstruction, which was such a blatant lie that my attorney nearly laughed himself hoarse when I forwarded it to him. That was the final straw. We filed a civil suit against the HOA and Karen personally for harassment, defamation, and breach of contract. And because I'd been so careful to document every single overreach, the evidence pile was thick enough to make their defense attorneys visibly wilt in the first hearing. In court, Karen tried to paint me as some vindictive newcomer looking to profit from technicalities, but under cross-examination, she had to admit she'd never reviewed the lease terms in full and had acted based on tradition, which made the judge raise an eyebrow and lean back like he'd just been handed a comedy script. The ruling came down hard. The HOA was ordered to pay me damages for the fence, legal fees, and a penalty for willful interference with property rights. And Karen was personally censured, barred from holding any position on the board ever again. The kicker, though, was the financial hit. Between my awarded damages and the legal costs, the HOA had to raise fees temporarily just to stay afloat, which, combined with the now public knowledge that they'd been charging residents for amenities they didn't own, triggered a mass push to dissolve the board entirely. Within 2 months, the HOA voted itself out of existence, turning control of the common areas back over to the property owners' cooperative, which, thanks to the original land lease, meant I was still the landlord, still collecting rent on every parcel they needed for access, and now there was no Karen to gum up the works. The day the final meeting adjourned and the HOA came down from their office wall, I happened to be sipping coffee on my porch when Karen drove by, slower than usual, avoiding eye contact. She didn't stop, didn't yell, didn't so much as roll her window down, and for someone who had tried to dictate the length of my grass and the paint on my non-existent mailbox, her silence was the sweetest sound I'd heard all year. In the end, they had tried to trick me minutes after I arrived, thinking I was just another homeowner they could bully into submission, but they forgot one simple, inconvenient truth. I was the one who collected their rent, and if you come for the landlord without checking the deed, you'd better be ready to pay the price, with interest.